is like any court case that happens in the criminal system. After you've entered a plea, which is probably a not guilty plea, if you enter a guilty plea, you'll proceed straight to sentencing. When I say straight to sentencing, that may be a month or two in the future, but there's not going to be an opportunity to review the evidence or to challenge it. So you'll plead guilty, and then the next hearing will be a sentencing hearing. If you plead not guilty, you'll get set on the pretrial or jury trial calendar. What that means is they'll first set up a pretrial, and that'll usually be about 6 weeks to 8 weeks in advance. The purpose of the pretrial hearing is to negotiate with the prosecutor. Okay, so we get their evidence and they review the evidence, and we go in and we have a meeting. It's in the courthouse, it's in the courtroom. Typically the judge isn't present, and we have a negotiation. The prosecution will extend an offer and then there'll be some negotiations. If they make an acceptable plea offer, then you'll enter a guilty plea that day, typically in writing before the judge, and then you'll get set for sentencing. If we can't resolve the case, which is typical, one or two things will happen. Either we'll have another hearing and there'll be more evidence provided, and another pretrial conference, I should say, or it'll get set for a jury trial. And that'll be the opportunity to take the case to a jury, to present your version of the facts, to present your defenses, and ultimately get an outcome. One concern that clients often have is they feel somewhat intimidated with jury trials, and when they see it on the calendar, they get worried that, I'm going to have to go to a jury trial on the 28th day of May, and I have no choices. And that's never the case. You will not be at a jury trial unless that's what you want, and it will be on the day that you're prepared to go. So there's some stress that's created when we get the notice from the court that says pretrial and jury trial. Clients start to get nervous, and that's the case. We'll have every opportunity to resolve the case. We'll have every opportunity to prepare the case, and we won't go to jury trial until A, you decide that's what you want, and B, we're prepared to do so. Within the pretrial jury trial scheme, your opportunity to fight is once you get the evidence in, you need, through your attorney, to file a motion to suppress or a motion to dismiss. And now there are just a ton of reasons why you might have grounds to suppress evidence and why you might have grounds to dismiss the case. Typically, the way that's done is through written motion. Once you receive the evidence, you write a motion, or your attorney writes the motion to the judge and says, Your Honor, for these reasons, my client's rights were violated and the evidence obtained should be excluded from court. There'll be a separate hearing for that. So typically what happens is you'll file that motion, and it gives you some negotiating power with the prosecutor. If you can't resolve the case, the judge will want to decide the issue that you've raised, and so they'll set it for a suppression motion hearing. And then you'll go to that hearing, you'll present your case, and the judge will ultimately make a determination. If you are successful and you've challenged, the essential facts of the case, there's a good chance the case will get dismissed by the prosecution. If you're not successful, then your backup plan is the jury trial. And so the best way to fight is to get your discovery early on, to review that discovery with your attorney, and file the motions. Get them in front of the judge and in front of the prosecutor. Get the upper hand in the negotiation process, and get ready for presenting your best case to the judge.